Welcome to this strategic explainer. Today, we're tackling a massive, kind of silent crisis right inside our own profession. You know the old saying, the cobbler's children have no shoes? Well, as elite legal professionals, you easily spend 40 to 60 hours a week bulletproofing your client's wealth. You're out there drafting absolutely ironclad contracts, navigating the wildest courtroom mazes, and basically building financial fortresses for other people. But here's the crazy part. Statistically, lawyers are among the professionals most likely to pass away with totally outdated estate plans, or if you can believe it, no plan at all. We literally know the law better than anyone, right? Yet we have this massive blind spot when it comes to applying it to ourselves when we're no longer the ones arguing the case. So today, we're shifting gears. We're transitioning from building client wealth to engineering and securing your very own personal legacy. We really need to address the ego in the room here. Look, it's so easy to just assume that because you know the law, you're somehow protected by default. But in today's landscape, especially with all the digital and tax complexities in our practices, saying "I'll get to it eventually" is no longer a viable strategy. Actually, scratch that. It's an absolute liability. If you're a high-earning attorney, your estate isn't just some simple checking account. It's a highly complex web of firm equity, intellectual property, and serious fiduciary liabilities. Leaving your legacy to the state's default mechanisms? That means leaving your family incredibly exposed.
Okay, let's dive into this. We're going to treat this as the master architectural blueprint for bypassing the public court system entirely. We have 6 pillars. 1. The probate trap. 2. The revocable living trust. 3. Funding and alignment. 4. Firm continuity. 5. Digital and tax defense. And 6. Sovereign legacy.
Moving right into pillar number 1, the probate trap. Public, costly, and slow. To build a proper defense, we first have to understand the structural flaw of the default state system, which is public probate. Leaving your assets to these default mechanisms isn't just a minor inconvenience, guys. It is a total loss of control. Let's break down the quantifiable catastrophe of this system. First up, privacy. Probate is completely public record. Ask yourself, do you really want your law firm's valuation, your debt ratios, and every little detail of your family's inheritance sitting down at the courthouse for anyone to dig through? Discretion is a massive asset, and probate literally destroys it. Second, the cost. We're talking 3% to 7% of your estate's gross value. The court doesn't care about the net equity you actually own in your real estate. They calculate their fees based on the total market value. And finally, time. We are looking at months, maybe even years, of frozen, vital family assets. Your family might desperately need liquidity, and it's just stuck in a judicial bottleneck.
Let's transition to pillar number 2. The master blueprint, wills versus revocable living trusts.
We really need to shift the foundation of your plan, moving away from a basic bar blueprint to a true wealth preservation model. The mechanical difference here is just brutal. Listen, a last will and testament is fundamentally just a letter to a judge. It literally requires probate to work. It's basically just a ticket to a courtroom. On the other hand, we have the true cornerstone of high-level architecture, the Revocable Living Trust. Think of this as a private contractual vault. It operates at the speed of trust, with zero court involvement. If you pass away or become incapacitated, a pre-selected successor just steps right in. Immediate transition, no friction.
On to pillar number 3, funding and alignment, activating the architecture.
I have seen absolutely brilliant litigators draft these gorgeous 50-page trusts, only to leave everything owned in their own individual name. That's what we call a dry trust, and honestly, a 50-page document is completely useless if it's dry. And this brilliantly illustrates our next point. To bypass probate, your assets have to be legally transferred into the entity you just created. You got to retitle your real estate deeds, update your bank registrations, and formally assign your business interests right over to the trust. The legal movement of these assets is what actually activates your protection. If the trust doesn't own the asset, it cannot protect it.
Now, obviously we're all human, right? You might open some niche investment account one day and just totally forget to title it correctly. Well, that's exactly where the pour-over will comes in. Think of it as your ultimate safety net to catch human oversight. It directs that any stray asset found in your individual name at death is simply poured over into the trust. But remember, any assets caught by this net will still go through probate, which is exactly what we're trying to avoid. So your primary goal is to keep that pour-over bucket as empty as humanly possible.
There are also contractual shortcuts that bypass the court altogether. Things like beneficiary designations on your 401ks, IRAs, life insurance, and transfer on death accounts. These are fantastic for skipping probate. But listen closely. Total alignment is absolutely vital here. If your trust logic says to divide everything equally, but your life insurance policy names just one specific child, well, you've just whipped up an instant recipe for litigation. Your trust should frequently be the primary or contingent beneficiary of these accounts, so your master logic governs every single penny without conflict.
Move into pillar number 4, securing law firm continuity, the ethics of succession.
Now we need to shift focus to your most complex and vulnerable asset, your own legal practice. I want to spark a really urgent thought experiment here. If you were gone tomorrow, what exactly happens to your active files? What about your ILT accounts? Or your pending contingency cases? If you're leaving all that to chance, you are flat out risking the ethical and financial consequences of your life's work. Without a plan, a judge might end up appointing some slow, clumsy receiver to come in and shut your firm down, completely destroying the immense value you've spent decades building.
The solution here is a piece of vital digital and legal infrastructure known as a Practice Continuity Agreement. This document explicitly authorizes a specific successor counsel to step right in, notify your clients, protect your deadlines, and cleanly oversee the dissolution or transition of the practice. By tying your firm into your structured planning, you aren't just preventing total chaos, you're actively protecting your family's right to the financial tail value of those cases you worked so incredibly hard to win.
Let's shift to pillar number 5, digital assets and tax defense, modernizing the vault.
We need to expand your blueprint to handle the realities of the modern 2026 landscape. Your estate isn't just paper deeds anymore. We're talking cryptocurrency keys, cloud-based practice data, professional social media profiles, maybe even AI-driven legal bots. Under the Uniform Fiduciary Access to Digital Assets Act, your estate documents absolutely must grant explicit power to your fiduciaries to access this digital wealth. Think about it. If your private crypto keys die with you, that wealth is permanently lost. No way around it. To solve this, we highly recommend setting up what we call a digital mallet. It's essentially a secure, heavily encrypted vault that stores the access instructions for your fiduciary, and it links directly back to your Revocable Living Trust. Simply put, your estate plan absolutely needs to be as technologically advanced as the legal practice that funded it in the first place.
Now, let's consider this crucial comparison. We already established that probate fees are calculated on your gross estate, which causes a ton of friction during the wealth transfer. Estate taxes, on the other hand, are calculated on your net estate, which causes what we call the erosion of your principal. Avoiding both that friction of probate and the erosion of taxes, that is the absolute hallmark of high-level wealth defense.
So how do we fight that erosion? With sovereign tax strategies. By using tools like AB trusts or credit shelter trust within your framework, married couples can effectively double their federal tax exemption. We can also deploy irrevocable life insurance trusts, or ILITs, to pull death benefits completely out of your taxable estate. This provides immediate, tax-free liquidity to your heirs. Really, for an elite professional, paying the estate tax is basically just a penalty for poor planning.
And that brings us to pillar number 6, sovereign legacy, the mandate of the sovereign.
So the crucial point is this: estate planning is not some morbid chore. It is an act of absolute leadership. It is the final argument you will ever make, and you won't even be there to present it. You spend your entire life applying brilliant technical precision to protect your clients. It is time to stop being the cobbler with no shoes. Apply your brilliance to your own legacy. Review your deeds, audit those beneficiaries, sign your continuity agreements, and fully fund that trust. I want to leave you with this final high-impact challenge. As we navigate 2026, are you just trying to predict the future, or are you legally engineering it? Get your vault in order. Thanks for joining me for this explainer, and I'll catch you next time.